This video is called What are Representations? Representations are a letter to the prosecution requesting the withdrawal of charges. The prosecution might be police, it might be the Office of the Director of Public Prosecutions or the DPP, it could be the Roads and Maritime Services or former RTA, it could be a council. It's a letter that goes through certain things and requests that the prosecuting body withdraw charges. That is, withdraw one of the two charges, for example, or withdraw charges altogether. Representations are sometimes called no bill applications, and no bill application means that you're asking for the prosecution to find no bill of indictment, that is, no charges against a person. However, I think representations is more accurate because you can sometimes request, for example, for 5 charges to be reduced down to 1, that is, for charges not to be taken away altogether, or for charges to be merged. For example, in fraud charges, someone might have 300 charges and you might ask them to be rolled up all into one charge. Representations. Now, in my view, representations are a critical part of criminal proceedings. When I say criminal proceedings, it includes proceedings for major traffic offences, for example, a Skies Law offence, a high range PCA offence, or any other type of major traffic offence. They're an essential part, and they're something that's used to seldomly by criminal lawyers. They should be used much more often because they can often result in someone's charges being significantly reduced or taken away altogether, and it can result in a happy client, it can result in a far lower sentence, it can result in your client being able to get on with their lives, and at the end of the day, that's what you want to do. Now, representations can be in a number of forms. You can have short representations, which may be only a couple of pages long in terms of a minor offence, or more commonly, they can be extensive representations. And in my opinion, extensive representations, longer representations, have a far greater chance of success. Now, when we draft representations here in Sydney Criminal Lawyers, what we're looking at doing is going through a certain procedure, a certain system, to give the other side the material that they need to draft their own reports to their superior. That is, for example, the police officer in charge may need to draft a report to the local area commander, or the DPP solicitor may draft a report to the director himself or to one of the immediate subordinates of the director requesting the withdrawal of charges. We want to give that person, that is, the officer in charge or the DPP solicitor, enough information for them to do their own report favourable to us. What I normally do when I'm drafting representations, I go through a step process. First is outlining the charges. So you say what the person is charged with, what the charges are. You say what our ultimate goal is, for example, to have all charges withdrawn, or to have, for example, an assault occasioning actual bodily harm charge reduced to a common assault, or, for example, a high-range PCA charge reduced to a low-range or a mid-range PCA, or whatever the case may be. Now, you outline the charges and you say what you're after in terms of the representations. That's the first thing. The second thing is you say what the police case is, or the prosecution case is, and normally that's contained in the police so-called facts, which I like to call the police allegations because they're not the facts. The police so-called facts. That's the second thing. The third thing you do is you go through the evidence itself and you find problems in the evidence. And when you're finding problems in the evidence, what you're finding essentially is that the prosecution cannot establish one or more of the essential ingredients or the essential elements of the offence. So you tell them where the case is not strong enough to prove one of those elements beyond reasonable doubt. That's the third thing. That takes quite a bit of time to go through the evidence itself. When I say the evidence, I mean the statements from the other side, any videos, any CCTV footage, any DNA materials, and so on. You go through all that and you show them where it's not strong enough. After that, that's the third thing. The fourth thing that I would do is point out to them what their own policies are. Now, there are DPP policies and guidelines. There are also police policies and guidelines. I go through the relevant guidelines in the representations. For example, a DPP policy is that if the admissible evidence available doesn't establish the charge, that is, doesn't establish each of the elements of the charge, then the DPP should consider withdrawing that charge. So I'll show them the policy, I show them the relevant guideline that they have, and the DPP policies and guidelines are published on the internet and they're readily accessible. All lawyers, all criminal lawyers should know these policies virtually off by heart, because you are really pointing to certain policies when you're asking for charges to be withdrawn. The next part, the fifth part, are the defence submissions. So after going through and pointing out insufficiencies, deficiencies, weaknesses, other things in the case where they can't make out the charges, you crystallise it in the defence submissions, and that's the next part of it. And at the end you reiterate that you want this charge withdrawn or you want that charge withdrawn, and you're asking for the withdrawal of charges. It is amazing how successful this particular procedure can be. We get a lot of charges withdrawn because of these representations, and again, they can be short representations that don't go through that process, and they may be just a simple request to withdraw, and that's for minor cases. But for a little bit more serious cases, you really should consider that you can do them yourself. You don't need a lawyer to do this. I mean, of course, a lawyer that's experienced in doing these things may well be able to point out the deficiencies, the weaknesses, other problems much better, but there's nothing preventing a defendant from doing representations themselves and sending it to the local area commander or sending it to the DPP solicitor. In any event, they should be used a lot more, because again, it really can make a huge difference to the end of the case. So those representations are drafted, they're sent out, and after giving the police or the DPP or whoever it might be some time to read and digest them, your lawyer or you should ring up and you should talk to the person about these representations. DPP solicitors will often sit down with the defence lawyer and discuss these representations in the case itself at a case conference, and this can make a huge difference to the case again. Now, criminal lawyers are criticised for going from adjournment to adjournment and doing very little in between. This sort of work, representations and negotiations of these charges, can make a huge difference, and really you should talk to your lawyer about whether they're going to do representations, if so, what they think they can achieve. Also, before doing the representations, what materials they're going to get. Also, for example, they might want a pharmacological report for a high-range PCA case, or they may want an independent fingerprint report, or whatever it might be, to give a lot of substance to your representations and get your charge dropped.